Hello.
Okay.
We at Machsom Watch, Women Against the Occupation and for Human Rights, are pleased to present to you the English version of a Zoom event by our military courts team, which was first heard in February 2021. Our military courts team has been active since 2006, but since March 2020, our volunteers have been denied entry to the courts due to the COVID-19 pandemic. Most of the military court shifts take place at the court in Ofer Base on Road 443 and in Jerusalem's Russian compound. One of our main activists is Nitza Aminov, who will tell us about the essence of the military court, of her own experience, and what goes on in the court. Nitza is also active in Women for Political Prisoners and in the Committee for One Secular Democratic State. Thank you, and now over to you, Nitza.
Good evening. My name is Nitza Aminov. I will speak of my own experience and that of my Jerusalem colleagues of Ofer Military Court. I began coming to Ofer every week since 2012. For me, being present at the procedure and speaking with Palestinians comes first of all out of solidarity, out of my desire to get to know Palestinian society and the understanding that at military courts one encounters the sum and substance of the occupation. Since the pandemic broke out, court sessions take place by video only. Only those who face extension of custody are brought to court, but for all others proceeding, the prisoners speak from the prison. When the lawyer speaks with a prisoner, the judge goes out of the room as if to allow confidentiality between lawyer and client. But of course, the lawyer cannot know who is actually next to his client in the prison, listening to what he says. Only one relative is allowed to attend court, and it is still called a court. Since March 2020, we have not been allowed into Ofer. Upon arrival, shouts are heard in Arabic in a violent tone. Wara el beton, wahad wahad, bas masari al cigara, meaning go back behind the barrier one by one, just money and cigarettes. Then we hear the name of the person summoned. A soldier shouts out from the loudspeaker and sits behind a glass partition. We approve our gate. The Palestinians are separated from us by a metal wall. There used to be a fence through which we could speak with them, find acquaintances, write down names of lawyers whom they asked us to tell them the family is out already waiting. Across the gate and metal detector that everyone has to cross, the soldier I mentioned sits behind his glass partition. The shouting and the orders continue. We enter, take off our shoes, remove the contents of our pockets, and place them aside. Pseudo-egalitarian, but I am allowed to bring a notebook and pen, a book and medication. If I have a cold, I can bring in tissues. The Palestinians are denied these things. I recall meeting Rassan Jarar, Khalid al-Zarar's husband, who had a bad cold and told me he was forced to throw away his pack of tissues and told to buy one by the snack bar. He told me he doesn't buy anything in this place. He told he doesn't want to buy neither tissues, nor water, nor coffee. Then we arrive at the yard and our shock continues. It is a large yard with rows of benches, a turnstile at the end through which one proceeds to small caravans called court halls. There is also a waiting room with chairs and a snack bar. We arrive and the conversations begin. Who are you? Can you help us? Stories of soldiers, incursions into homes at night, and on and on. One gets dizzy. We, the privileged, cross the turnstile and are not asked a thing. We enter the hall, and with us enter two relatives of the detainees. On the bench, facing a wood partition to which plexiglass has been added lately, making it more difficult for the relatives to communicate, 4 detainees sit with their feet shackled, handcuffs removed. The court session begins. A military judge, a military prosecutor, and a soldier who translate from Hebrew to Arabic for the benefit of the detainee. In the hall, for instance, there are always several lawyers working at the same time. It is impossible to hear a thing. The lawyers inquired at the court who they must represent. Then they find their client, they approach him. This is, in fact, the first time they meet. The lawyers tries to explain what is going on to the client and to the relatives as well. The whole time, the detainee tries to talk with his relatives. Often, this is the first time the family sees the detainee since the arrest. The whole farce lasts several minutes. A protocol is printed in Hebrew. One copy is given to the detainee. The guard orders the relatives to get out, and the next family is let in. Later, we learned to take the sessions list and then noticed that sometimes there were over 60 names to be tried in a single day, a real assembly line. At 1:30, a break is declared until 2:30. Palestinian relatives of the detainees leave home early in the morning to get to court on time. Naturally, they don't know when the session will be held. Sometimes they stay until the evening, but no one will give up this opportunity to see their relative even for a few minutes. I recall a young Palestinian who turned to me in Hebrew and said, "Here one can be acquitted, right?" Picking up my dropped jaw, I said, "Here?" And he answered, "But this is a court, isn't it?" I also recall a Palestinian who turned to us and asked for explanation and said he had never been arrested before. We told him he is probably the only Palestinian who has never been arrested. Later, we learned how this place works. We spoke a lot with lawyers, with people. We witnessed many sessions, including minors, and it's still not clear to us how this place can be called a court of law. With time, Palestinians get used to our presence. Naturally, the expectations, both expressed and implied that we helped them have not vanished. Often we were asked to join them in the session, assuming our presence could matter. Often we have translated protocols since I said the sessions are short, translation are unclear, and it is difficult to understand what goes on. We heard endless stories of family denied work or entry permits into Israel as soon as a relative is in custody. But why? We were asked repeatedly, and we explained again and again that this is the occupation. And explanation is due. The military court system, together with the civil administration and the army, are the three mechanisms of control through which Israel, as an occupied power, enforces its control over the Palestinian population in the West Bank. The military courts were established by Military Security Order 1920. Some of the judges are professional military personnel. Others are lawyers who serve as a temporary military judge in the frame of their military reserve service. The same goes for military prosecutors. Court translators are usually regular army soldiers. A military order issued in 2009 expanded the court's authority over Palestinians who commit a crime in Area A if the crime harms or intended to harm West Bank security. As a result, the military courts now have authority over every Palestinian who commits a crime which is considered a security breach. Area A, according to the Oslo Accords, it is meant to be under the security and civil control of the Palestinian Authority. One of the most problematic procedures is detention until the end of proceedings. This procedure entails the detention of people whose investigation has ended. Detention until the end of proceedings means that an indictment was filed against the individual and his or her detention continues until the end of legal proceedings. It is important to stress that we are not talking about an actual prison sentence, but rather the detention of a person who hasn't been convicted yet. This person should benefit from a presumption of innocence. In the majority of the cases, the judges are not willing to consider alternatives to the detention in jail. And in the few cases when they do, the alternatives are heavy fines, which can add up to tens of thousands of shekels. I remember a case of a young girl from the Haitian refugee camp who was arrested over a post she published on Facebook. The prosecutor demanded, of course, detention until the end of proceeding, while her lawyer pleaded for an alternative of house arrest, disconnected from the internet and the mobile phone. The judge shouted at her lawyer, "What? Do you think the army can send soldiers to check where she really is disconnected? She should remain in detention." The extension of detention is one of the reasons for plea bargains. For if there is an order of detention until the end of proceedings, and the detainee is willing to argue his case in court, the period of detention until the end of proceedings might exist the terms of the sentence that he would get if he would have a plea bargain. A sentence of innocence or exemption of all charges is out of the question anyway. I will not burden you with all the inequality and biases of military orders in comparison with the laws in Israel. Suffice to say that Palestinian detainees can, according to the law, be kept in custody for 8 days before they are brought before a judge and can be banned from seeing a lawyer for the first 96 hours of their detention, a period where the General Security Service is allowed to interrogate detainees. Usually, 4 hands cuffed detainees are brought together with a judge. The handcuffs are removed once they are seated. At this point, the lawyer starts talking with the detainees, and as mentioned, this is usually the first time they meet. The procedure allows 2 family members to be present at the time, one family after the other. Usually, the detainees look for their family as soon as they enter the court. A conversation and exchange of information starts with little attention paid to the procedure. Often, the detainee report that all is well in prison, that they met friends in attempt to ease the suffering of their worried and weeping parents. Sometimes they recount hard stories of interrogations, of the conditions in the prison, and are eager to hear about their family and homes. It is heartbreaking to see a detainee looking towards the door, expecting to see family members and have not arrived. After the short deliberations the soldier pulls the family out and allow the next family in. Often they are heard shouting, "This is not a visit, out." Actually, these are really opportunities for visits. For the families, it is not easy to reach the jail visit. Now everyone gets a permit to visit, and getting to the prison and back sometimes takes the whole day. Throughout this whole time, the prosecutor presents to the judge the indictment sheet or a request to extend the detention period. The defense lawyer usually objects and asks for details and explanations. The lawyer doesn't receive an answer. At times, the prosecutor refers to a secret report, which is presented only to the judge. Many times there is feeling that this is a premeditated charade where every actor knows his or her role. Many times the defense lawyers ask for a postponement, which is often granted if the indictment sheet has been submitted and deliberations about a plea bargain are taking place. The lawyer updates the detainee, usually when he is brought to the court, and his family of the current status of the bargaining. Every plea bargain includes a fine. On rare occasions, the family is even willing to pay heavy fines in exchange for a reduction of a few months of jail time. This is especially true with minors, where the family wants their child freed so he can continue with his education. This is also the case when husbands want to reduce the sentence of their wives and mothers of their children. Once a plea bargain is struck, the prison sentence period is counted from the first day of detention. When the prosecutor declares that a plea bargain has been reached and presents it, the show continues. The judge declares that the court is not obliged to accept the plea bargain, but it always does. At this stage, the detainee accepts the plea bargain and admits his guilt. The admission of guilt has far-reaching consequences for their future, theirs, and that of their family. Usually, the plea bargain includes an article of suspended sentence. In recent years, this article have become harsher and could reach up to 18 months of sentence for a period of 5 years. It is quite clear that severity of the suspended sentence is meant to keep Palestinians away from any activity associated with resistance to the occupation. In June 6, 2019, Amira Haas published in Haaretz an article entitled "A Mountain of Palestinian Cash," and I quote, "Since the 1990s, tens of millions of shekels have accumulated in the accounts of the civil administration from bail paid by Palestinians. This is addition to the fines. Of course, the actual amount collected is much higher." In 2015, Yair Golan, who was then deputy chief staff, said that what frightened him in the memory of the Holocaust, Shoah, was the identification of processes that took place in Europe that he could find here. In this context, the journalist Bet Michael wrote in May 15, 2015, an article in Haaretz, and I present part of it that refers to the military courts. A judicial inferno where there is no presumption of innocence and no rules of evidence and no justice and no mercy and no compassion, but there is a court, a ridiculous show whose main purpose is to give an orderly and lawful vestige to wild military dictatorship. How can one detain a person for years without due process or fair trial or any judicial scrutiny over the alleged charges and without the basic right for defense? The answer is administrative detention. Administrative detention in the West Bank is carried out according to military orders concerning security, where administrative detention is defined as a preventing detention, and therefore there is no indictment but only suspicious. The procedure exists in Israel too, and goes back to the mandatory legislation turned into the law of emergency power in 1979 and is renewed yearly. This is Bushra Al-Tawil, is a photojournalist from El Bire, which is next to Ramallah, who has been detained several times in 2011 and 2017. And she is in detention. In July 2009, a new law for minors was adopted in Israel. At the same time, the military commander of the West Bank signed an order for establishing of the renewed military court for minors, boasting about it as if it was a replica of the law for minors, to which it, in fact, is bore almost no resemblance. We witnessed many court hearings for minors. We were allowed to enter the court hearing only after the judge had asked for permission from the family, the defense lawyer, and the minor themselves. Our names were registered in the protocols, and we were duly warned to keep the secrecy of the hearing, all in defense of the minors' rights. However, the reality is that we heard time after time how the minors were arrested not through an arrest order, but rather through night raids, and many times the minors were kept secret from their families. Many times the arrest took place immediately after school and after a provocation from the soldiers, which caused the minors to throw stones. Many times the defense argued that a youth interrogation was absent or that neither parent was present during interrogations. We witnessed the hearing of a 16-year-old girl who was shot and wounded at the time of her apprehensions. Her interrogation took place in hospital shortly after her operation when she was in the recovery room. The interrogator said he knew Arabic, but just in case, he asked one of the Palestinian hospital janitors to translate for him. We heard the recording where it was clear that the girl was still drowsy and it was not possible to understand anything. I recommend visiting the websites of these organizations. Parents Against Child Detention and DCI, Palestine Defense for Children International, two organizations that carry out very valuable work. All civilian activity in Palestine is the activity of a terrorist organizations. This is a statement by an Offer Military Court prosecutor, 2015, overheard by me. Since the occupation of the West Bank in 1967, Israel targets civil society organizations, all aid organizations, and organizations focusing on orphans, prisoners, kindergarten, schools, and more are declared illegal associations, and their staff and administration are targeted for indictment and arrest. The terror that Israel practices is aimed also at university students, but mainly Birzeit University, where student activity is mainly that of the students affiliated with the Popular Front for the Liberation of Palestine. Male and female human rights activities calling for popular, peaceful resistance to the occupation, and journalists are often detained. Writers such as Ahmad Katamesh, academics such as Professor Imad Barghouti, who is here on the down with the red shirt, Ubay Aboudi above him, the director of a research center, are but a few. On November 2nd, Khitam Safin was arrested and taken from her house in Betunia. She is up on the right side. She serves as the president of the Palestinian Women's Association, as known feminist activist. She was sentenced for a 4 months administrative detention, which was not her first. On the eve of her arrest, Muhammad El-Azza, a human rights activist from Khobar, was arrested. Shada Hassan and journalist Bushra Tawil were arrested at November 9th. Muhammad Asgharayer, a human rights activist, is in jail. Khalid Azarar, a Palestinian legislative council member, is in Damoun prison. She was arrested October 31, 2019. Her legal procedure continues. This is not her first arrest. Mais Abu Rosh, which we see down to the right, was arrested on August 29, 2019. She was thankfully released 2 months ago, but most students have been arrested. Let us tell you about Issa Amro from Hebron. He is down in the middle. A peaceful activist arrested multiple times. He insisted on conducting his trial of evidence phase, in which we heard witness testimonies about the ill treatment of the residents of Hebron. His trial was concluded in February, and he was found guilty in 6 out of the 60 counts listed on the indictment sheet. His sentence will be issued shortly. The fight against civil society organizations isn't one against a specific political faction or party. An example is one case against the Women's Committee in Hebron. 7 female activists were arrested. Each was sentenced for 1 year in prison, charges being members of Hamas. Here we can see in the middle Lama Khater, which was one of them, in the day she was released from jail with her husband. It is clear that civil society organizations are the basis for the creation of a free and a critical society, and notion that frightens Israel. Education is the enemy of the occupation, and the other way around as well. The occupation is the enemy of education. Israel wants to control a society that is ignorant and unaware. It is much easier that way. It is important to point out the ongoing activity of the civil administration in the destruction of different communities. Elementary schools are regularly demolished, especially in rural areas. Through the conversations carried out in the courtyard, families tell us so many stories and provide details of the ill treatment they experienced under the occupation, the longing for how things were before the separation wall, when they were able to work in Israel and visit their villages from which they were expelled in 1948. They are always interested to hear about us as well and about what motivates Israel women to come to military courts and what we think of the courts and of the occupation. For example, when I go looking for the families of detainees from refugee camps and talk to them about their original villages, they are always happy and keen to share, and at times they are surprised to learn that I know the names and recognize the place. We have been in many court hearings of women. It is always hard when we hear of a woman who comes bearing a knife to a military checkpoint with the intention of being arrested. Many harsh stories about within the families. For women are victims of both the occupation and patriarchy. Sometimes an Israeli prison is their only way out. What more can we say? Maybe we can talk about Arish Hoshia, a young girl who took her disabled sister to Jerusalem to be tested. She was apprehended at the checkpoint, was examined with her clothes off in the presence of men, and then took her headpin, said something to the woman soldier, and was apprehended with a charge of attempting murder. Attempting murder with a pin. I want to show you. This, in Arabic, we called it the bus. This is the pin. And maybe we can talk about the language of the court. In Palestine, there are no demonstrations, only riots. Posting at Facebook is always incitement. An investigation using torture is a necessary. Indictments are often worded as such, on this or that date, in this location or nearby. And then the plea bargain states evidentiating difficulties, of course. All this does not prevent the conviction, because what is most significant in the military court is the proof that everyone who is arrested is guilty. The rule of innocent until proven guilty does not exist here. I encourage you to read our report called Master's Rule, prepared by the Machsom Watch military courts team and written by Chava Halevi, a member of the team. The report is available in Hebrew, English, and German on our website. And to end this presentation, I want to add something that seems important to us. After witnessing many court hearings in the Jerusalem District Court in cases dealing with the East Jerusalem resident, we noticed a big gap and difference in the severity of the punishment when dealing with Palestinians who are Jerusalem resident and have residence in Israel, or Palestinians who are West Bank residents. Those who have a Jerusalem residence are exposed to much harder sentence than those who are sentenced in the Ofer military court. Surprise. An example, a very known case is the case of Nurhan Awad, a so-called in Israel scissors girl. In 2015, she arrived from Kalandia together with her female cousin, Hadil Awad. Nurhan was 16 and Hadil 14. They managed to get to Machane Yehuda market in West Jerusalem, where Nurhan managed to slightly injure someone with her scissors. Both girls were shot. Hadil was killed and Nurhan severely wounded and got to hospital. The district court sentenced Nurhan to a 13.5-year sentence, from which 3.5 years were reduced in the appeals court. On the other hand, the story of Natalie Shuha and Tasnim Halabi, quite similar, has a very different outcome. In April 2016, they arrived from Ramon village near Ramallah. Two young girls who left school with the naughty thought of doing something against the occupation. They thought of stabbing a soldier at the checkpoint, and soon enough they were shot at. Natalie Shoha was wounded and transferred to Hadassah in Karem Hospital. Tasnim Halabi was arrested on the spot. At the Ofer military court, they were convicted at an attempt to stab a soldier and sentenced to 18 months each. We cannot explain the difference in the harshness of the sentences. Thank you.
Thank you to Nitza for her bravery of attacking her remarkable lecture in English. So I thank her, and I want to clear up confusion because Nitza Aminov was our speaker today, but she was using Yvonne Mansbach's computer. Therefore, if you saw the name under her picture, it mentions Yvonne, who is right next to Nitza and has been right next to her throughout the preparation of the presentation. So I want to thank Yvonne and also to thank Vivi Suri. And I want to thank all of you for being with us. And I also want to encourage you to turn to our website, MachsomWatch.org, where you could find lots of fascinating material about the military court and about all of our activities. So thank you and see you again.
Inshallah.